Hello, everyone. Good afternoon. Uh, on behalf of the ASSOCHAM IPR Council, I welcome you to this workshop on trademark search for startups and MSMEs. I'll first start off with a brief introduction to our speakers today. We have Preeti, who's an examiner of the Ministry of Commerce. People to be on mute if possible. Thank you. So Ms. Preeti is an examiner of trademarks and geographical indications, or GI, at the Ministry of Commerce and Industry, DPIIT. She's been there since August 2017, having completed her LLM in Business and IPR laws. She has delivered lectures on various IP awareness programs, such as the awareness programs for IP Office, Afghanistan, IP awareness program for the students of the University of Pennsylvania, and programs for MSMEs at IMT Industrial Association, Manesar. We also are joined by Mr. Harsh Pangi, who is the founder of IP5. Harsh is building a purpose-driven brand, IP5, which is an IP consulting firm operational from Belgaum and Bangalore in India. He has a diverse professional experience of 17 plus years working in the field of engineering and technology with companies like Infosys, Tata Elxsi, and in the field of IP with SAP Labs. Having known Harsh, I know he's an innovation coach with Institute of Inspiring Innovation in Bangalore. He mentors and advises different startup accelerators and consulting. He's registered to practice as a patent agent with the IIS India and holds a Master of Science degree. Uh, welcome, Mr. P. Welcome, Harsh. Thank you for joining us today.
Thank you, Hemang.
I am Hemang Shah. So in my work hat, I work for Qualcomm and I lead our startup incubation program. Since 2016, we have incubated 77 startups. These are hardware IoT startups which have created remarkable products in the areas of drones, medtech, smart cities, agri-tech, electric vehicles, and many more. Collectively, these startups have filed for more than 250 plus patents of their own. They are building IP. We have also, 2 years ago, started a program to mentor entrepreneurs. With we have worked with 26 startups, and these are mostly in the deep tech arena. The scope is a bit broader, and again, they are IP savvy. Now, in working with these startups, we realized that there was a gap in terms of IP awareness that is available to the startups, and that's usually because uh, when professionals like Harsh or Ms. Preeti are in front of them, the startups questions tend to be answered very fast. But innovation happens outside of that scope. So with NLU Delhi and with DPIIT, a program was launched which is called as L2 Pro. And L2 Pro is an IP e-learning platform. It is completely free to use. You can access it through the website directly or through app stores for whichever phone you're using. It will allow a startup founder and CTO, like anyone who's working with startups or SMEs, to really understand the value of the IP that they are building. How they can protect their innovations with patents, how they can work on trademarks, basically integrate IP considerations as a part of their business models. The program is split across 3 categories: basic, intermediate, and advanced, and it's a completely self-paced program. Now, at the end of each level, there is an assessment which is based on case studies. So, case studies which mimic the world of a startup. And really, the goal is to make it actionable at your end. And because it is meant for a non legal audience, the material is also presented in an easy to use format where things are highlighted in such a way. For example, here's a screenshot that we are showing where you can find the list of patent and trademark facilitators on the IP India website. Where can you get these resources? There'll be pop-up questions which will come up. And considering everyone, wants, really fast information all the time, we have introductory and summary videos which are of 2 minutes duration. So for each lesson, you can spend about 5 minutes and you can learn about 60 to 70% of the content. And if you want to go deeper, then you immerse yourself in the lesson itself. And for folks who complete the assessment successfully, a certificate will be generated on the spot. So I won't play this video. I already played a video at the start of the session, so that was something from our trademarks program, uh, and and I think it is now time to dive in, and I'll turn the floor over to Ms. Preeti. Ms. Preeti, just allow me to stop sharing my screen. Ms. Preeti, I now invite you for your remarks, and please guide startups and SMEs on how they should think about trademarks.
Thank you. Thank you so much, Mr. Shah. Thank you so much. So, my name is Preeti. I'm an examiner of trademarks and GI. I got to this registry, I got attached to this department by 2017. And being on this side of the table, being an government employee, we actually go through several of trademark applications in a year or a month or in a day, you can say that. And where we actually find it that it is the dire need of people to make them understand that actually IPR is in need of an hour, and then at the same time you need to actually enlighten yourself, or somehow the brain exercise should be done on the part of the public at large when they are choosing a mark to be get registered as a trademark before us. So here the innovation is actually the main criteria, importance, or the eligibility condition to get a mark or a proposed thing or an idea which you want to be get as registered as a trademark is important thing. As I came to know that this is a mixed audience, so I would cater for like many of the people do know that what a trademark is, what kinds of the trademarks are, but still because few people are from the academics and all that. So I actually have a PowerPoint presentation with regard to where we have specifically categorized the trademarks, and we actually look upon those trademarks when we get these applications and we actually categorize them. So I would like to go with that presentation, and then along with that, I would like to keep it interactive also. If somebody have any kind of question, everybody is welcome with regard to that. Is my screen is available to everybody?
Not yet.
Whether it is shared now?
Yes, ma'am.
Yes.
My slideshow button is not working. I'm so sorry. Right?
Now it's
So
good. Yeah.
It's fine?
Yeah, it's perfect.
Okay.
Yes, ma'am. Fine.
Yeah, ma'am, this is fine.
Thank you so much. So everybody being on legal fraternity, I just need to make them understand that yes, everybody, it was an idea behind earlier that property, which is something, it is in tangible form only. But later on, with the passage of time, somehow when we got ourselves enlightened, we get ourselves enriched. So similarly, law do get changed, and it has actually made people understand that property is not a tangible form only which can create a wealth, but it is an outcome of your brain also. Your ideas, your creativeness is something which actually go with the that what is technically a property. So intellectual property is also a form of property, which is basically an exercise of human brain. It is actually the fruit of your brain. It is actually the exercise, the thought process, which somebody have an ability to actually incorporate in a creative manner. And at the same time, it is so distinctive that you have this ability to get it distinguished from the rest of the people. The services and goods are irrespective, but yes, something which is the outcome of brain and which has been so creative in nature is actually intellectual property. These intellectual property at the latter stage are actually clarified that whether it is a design, it is a patent, or it is a geographical indication or a trademark. I'm so sorry, my system is actually getting hanged. So the next slide is not moving. As I have told earlier that IPR is in need of an hour. And the moment I have discussed that these are the types of the intellectual properties which we being an IP office, I am the one who is dealing with trademarks and GIs, but then again the IP office is something which deals with each and every kind of intellectual property rights. It includes copyright, it includes patent also, it includes designs also, semiconductors and all that. Me being from a trademark examiner, our head of office lies in Mumbai. And then other than Mumbai, we are having 4 other branches also, which are in Ahmedabad. One is in Delhi, the other was in Kolkata, and the next one is in Chennai. So we are technically, trademark does have 5 offices. Patent do have 4 offices. They do not have an office in Ahmedabad. And with regard to GI, the GI head of office is only in Chennai. So when somebody comes for a GI, so that is something which is only catered for in Chennai office only. And copyright is also exclusively in Delhi. Copyright office recently got merged with office of CGPDTM. Earlier it was with DPIIT. Coming to the trademarks, which is my technically assigned thing or assigned designation, and I have actually this is my short span of knowledge. So for according to me, trademark is something which can be a name or a word or a phrase or a logo, design, sound. So these are the categories. Please, when I say all these things, one need to understand, even small SMEs, MSMEs also need to understand that when they come before us, even if they want their name to be get registered, they need to understand, they need to categorize their mark, that whether the name actually do fall under the category of a word mark or does it fall under the category of a device mark. Because once you add an image or a character to it, the category of the trademark do gets changed. At times I have realized that people also misapprehend. They think that by changing the category of the trademark, the fees of the form also do get differentiated. The fees is same. Fee does not get affected by the changing of the category of your mark, whether it is a word mark or it is a device mark. Fees is irrespective. I have seen people came across, they have what they have done, they have took 20,000 of demand draft in name of registrar of trademark, and they're like, this is my name which I need to get it registered, but this is my image also which I need to get it registered. And then in a single TMA form, they're applying it. So it is actually a task to make them understand that when the category of trademark has nothing to do with it. People need to understand that this is a specified fee and the fee is 10,000. And for SMSC, you know that it is 5,000, there is 50% rebate. So even government has taken initiative to benefit and to actually promote these MSMEs, small industries, micro industries to come forward and to get themselves somehow IP enriched, and we want their IP to be get protected. And somehow, because when internationally or even globally or nationally, they want their platform to nourish themselves, then somehow it is required in this technical era to get their mark to be protected, to get IP to be protected. So technically, trademark is a source where your goods or your services are distinguished from others, from the rest of the people, from the public at large. And this combination of mark or anything which you are applying is actually nowhere affecting to the fee. And you need to understand that yes, trademark is something which is outcome of your brain, and this is a very common line. Everybody must have gone through this thing, that from head to toe you go through trademark. The moment you get up and the moment you go back to your bed, it is actually you go through the trademark, but it is just that people are not enlightened that it is trademark. The brush you are using, where we start from our morning, is actually trademark. It does contain a design, it does contain a color combination, and at times if you're specifically using an Ayurvedic toothpaste which has been outcome from a particular paste, then at times it do contain GI also. Somebody must have the brush, the bristles it is having a patent also, because the brain was intellectually applied over it, and the thing has been an outcome. So while applying for, or when approaching for a trademark, one need to understand that there should be an outcome, and it should not be copied, because if it is copied, then automatically this is called the infringement of trademark, and this is what unregistered trademark holders are actually facing. When they do not get themselves protected, when they do not get themselves somehow connected and they are not enlightened, they're not acquainted to the law or to the things. So these are the things. And earlier there were, with the, as we say, that passage of time, law is not static, law is dynamic, it do changes day to day, because the need of this are actually do get changes. So this is the thing. Earlier there were the only conventional kinds of trademarks where the only word, letters, numerals were the kind of the things where people do come before us and they wanted to be get registered. But sooner this filing of the trademarks do get changed, and then we started getting unconventional trademarks, which we see on this side of the table, but right these days it is normal. So there we started getting color trademarks, we started getting sound as a trademark, we started getting holograms. I just need to though I know that somehow MSME or SMEC is not and somehow actually related to the coming line which I'm going to say, but I think that I should utilize this platform. According to me, right now India hasn't gone for a smell trademark. So I forgot to add. So even smell can be get registered as a trademark, but India still hasn't got any smell trademark file. And even I don't think so, being on this side of the table I should say it, but I don't think so whether we do have a kind of module or a thing to actually examine a smell as a trademark. But then I literally want to utilize this platform and I want to convey to the people that please go for a smell trademark also. Please, when you actually brainstorm yourself, now you can actually get us to make us to amend our act and amend our law and make us understand that yes, these things can also be incorporated as a trademark. So I don't want, because law is not something which is conventional, it is the need of hour and it actually gets changed. So I actually wanted to make understand that even SMSs also, even micro industries also can come with a color combination, and they can propose that this is my small industry, this is my micro industry, and this is how I want to get my micro industry to be get registered as a trademark. Because it is a common thing. Instead of words, instead of what I'm saying, whatever I'm saying, I actually could have delivered it to you very well. But then this is example, my PPT can attract you. It can attract you guys. It can somehow make you guys to engage with me what I'm saying, right? So this is the purpose behind of getting a creative trademark, to attract the public at large, to stand distinguished among the public. The unconventional trademark are the best approaches for the team, right? So this is somehow I just need to make the MSMEs also.
आकाश टेम्पल चलेंगे आज शाम को, ठीक है, जालंधर, फिर शाम को आएंगे 9 बजे 9-10 बजे से।
Request to be on mute, please.
खाना वहीं पे हो जाएगा फिर।
Okay.
Okay, so these are the kinds of the trademark. Again, I'm sorry, my system is getting hanged again because. So I'll continue till the next slide will come. So in the coming slides also, I have actually described all these kinds of the trademark, that how a word or a letter was the is a kind of trademark, or and how to. So this is the next slide which I automatically got popped up now. So this is the example of color trademark. This is what I'm trying to make the micro industries or the small industries to understand, or startups. I want them to understand that just don't come with like XYZ Private Limited. We have seen that thing also. And then unwillingly or with a heavy art or being practical side of thing also, now what we do, we actually have to raise an objection of 91A. We state 91A says that the proposed mark is actually does not have a distinctive quality. The qualifying ground for getting a trademark to be registered is like it has to be distinguished, it has to be creative, and at the same time it should not be copied. So innovation, IP main agenda is to actually somehow promote the innovation, actually to make the people to brainstorm. So these are the things. When you go for, I don't think so nobody care for Cadbury or dairy milk if it is kept on a shelf. So everybody know from a distance that this is Cadbury. right? So this is the thing. We know that this color combination of blue wrapper is actually the Cadbury. It is actually the color combination which have attracted the people. This is what I'm trying to say, that come before a mark but then try to make it creative. You yourself can actually have a brain exercise, get your questionnaires outside, and you can get a certain amount of audience, and you can actually testify that what is the thing which can allure the public at large, and through which, because while making a startup, I think on technical side what startup people do, they know, okay, I need to work on this particular zone, and this is like one of the what we can say, this is these days discussed most, this is the highlighted one, so I need to go for it. When you actually examine that in what kind of business you should go for it, then please examine also at the same time that what is something which is through which people are attracted, right? The moment I said that my ppt can engage, in the similar manner you should come with such kind of trademark that can engage, where even the office also can't somehow at any of the objectionable ground, which is like prominently section 9 and 11 of Trademark Act, we would not be able to cite, right? So these are certain examples where I have actually said that this is somehow you should go for a color trademark. This is my personal choice, but person to person varies. Certainly it might happen that even for a word of work mark, if it is in a stylized manner have put before us and it is having some distinctive quality and it is not somewhere copied, so it also can get registered. So this is the thing. Also, then coming to the sound mark, I think the best example is the Tarzan yell. Everybody has gone through that. So even the sound marks are the subject matter of getting trademark. So why I'm telling you sound mark, because the way now Mr. Shah has opened a video, right? So it was having a sound, or even if you're presenting your company before somebody, I would suggest, like when you actually open the PPT or somebody comes for it, it must having a different sound. You can get that sound also somehow trademark. It will actually, why I'm telling you these things, reason behind, because when you get these kind of things with you now, it will actually somehow make you more presentable before somebody else with whom you want to extend your business, and it will show that you are very well versed with the law, and at the same time it will try to convince the other side of the people also that the person is very much serious about their startups. Because I have seen that people are initiated the startup, they have taken the trademark, but then they are no more practicing it. It has gone into the dustbin. So at the big, if you are very sincere towards it, if you're sincere with getting these marks, and if you're sincere towards your business, so this mark, trademark, it actually plays a vital role. Like if we know that once, if you remember Nokia's phone, so when it was first time, or somebody who switch offs or when switch on the phone, so there were the hands which used to come, and then a sound used to come behind that, right? So that sound at the same time is registered as a trademark. So this is what I'm trying to suggest. Like when somebody comes for a startup, or if somebody is trying to find it out on Google or any social platform, get yourself such a different thing, and get those registered different things, so that when they won't be able to forget. So trademark is something which actually can help startups, MSMEs, or a single firm, or any individual, or whosoever comes, to actually get your impressions imprinted in somebody's memory. So this is what my personal thought process is. So when you go for it, you should think about these things. So packaging can also be packaging can also be a kind of trademark. Tiffany and Company is the most prominent one example, because me being the female, so no offense to anybody, but yes, every girl do have this dream to get patch outs from something Tiffany and Company. So its packaging itself does know. Every girl does know that this blue and white packaging, if everybody is looking at this thing, this blue and white packaging is actually which belongs to Tiffany and Company. So your packaging is also a kind of a trademark. So if somebody is dealing in kind of manufacturing, any startup whose packaging is of different kind can also get registered as a trademark, and you can actually gain a certain amount of audience also. Those packaging should be comfortable. Those packaging should actually reflect your product. Those packaging should actually show that what you are doing, it can be eco-friendly. We have gone through several things. These days are like, it's jute bag, it is my eco-friendly bag, and my bag is like having a portly manner. Mine is having a zip lock, or mine is like easily to open and easily to pack. So these are the things that how this packaging does have effect, and these packaging at the same time get registered as a trademark. So when if some startup is dealing in some kind of manufacturing, and they're manufacturing their own box or their own packaging things, so in the same manner they can deter the public at large not to use their packaging, and they can stand themselves by getting it registered as a trademark. Right. So this is the thing. I am getting the question. So is it possible? Can I complete my PPT and I can come to the answers, or I am supposed to answer these questions at the same time in this topic?
No, we could cover them at the end.
पहले आंसर कर दीजिए.
Pehले answer. So can I go? So can I go with? Can you please give me your questions, because right now my screen is actually desktop is only having the PPT.
Sir.
Can you repeat?
Ma'am, our questions.
Go ahead, Abhijit.
Please say your question so that at least I can answer.
Okay, while he comes up, a question आया था by Mohammed Maz Hussain. What is the fee for trademark registration for new startups or incubators?
What is the
Fee for trademark registration.
fee for trademark registrations?
Fees, like how much does it cost to register a trademark for a new startup?
For new startup, so for new startup, the form fee is 4,500 if you file it online, and 5,000 rupees if you file it offline. And I would like to also add that when you are filing it online, you are supposed to have type 2 digital signature, because unless until you are not having the signature, actually you can't submit your form on TMA. Right, so the TMA is an appropriate form to file a trademark. Very first thing, the appropriate fee after 2017 is 4,500 if somebody files online. We have given it 10% rebate. But if somebody is not having type 2 digital signature, then it is suggested to get that form TMA uploaded from the website, which is www.ipindia.nic.in. The forms are available there. Upload that form in Word document and then type it and sign it. So the handwritten form is not acceptable. That is the limitation. So then please type it on the Word format only, and signature are acceptable by hand. And then you can get a demand draft in name of Registrar of Trademarks. And then you can come to the office and it can be submitted. And the jurisdictions are divided. So if somebody who is from Uttar Pradesh is supposed to come to Delhi, but somebody who is from Rajasthan, their TMA form is accepted at Ahmedabad office. So the India has been divided in these 5 territories. So these details are also available at website, which I have just quoted. I'll again quote it, www.ipindia.nic.in.
I'll share the website link in the chat box. And Preeti ma'am, there are 3-4 questions along different topics. So I feel it might be better if you can complete your slides, क्योंकि आपका पूरा वो flow चला जाएगा फिर.
Certainly. Okay. Thank you so much. And if there are any other questions left, I'm open. You guys can take my email address from me and I'll answer it from there. So that is fine. So hologram is also something. Hologram is actually the graphical representations, and these can also get registered. I would like to mention that as far as I know, China was the first country who actually got holograms as registered. So this is the picture. This is not exact. This is the mandala holographic picture. A female folding hands, and it has been graphically represented, and at times it is represented in 3D manner and with the whole lightings and all that. So this is how hologram can be registered as an trademark. So even anybody can come with holograms. Holograms also can be get registered, and industries can actually utilize these kinds of trademark to establish themselves. So I'm not asking the startups or anyone who is right now listening me to actually apply these marks in this sense, right? I'm just giving you the categorizations. Other than word, normally in form, it will only considered as device mark. But why I am categorizing it for you so that you guys can understand. So if anybody whosoever does object your application on any ground, you can actually somehow make them understand that mine is a holographic figure. So it does have more sustenance value or more prominence in comparison to the rest of the objections, which a considered examiner, respective examiner must have raised, right? So the category while filling up in the form will be only word mark or device mark. So rest of the characters which I'm discussing now, like hologram or color combination, all these falls under the device mark only. I'm only discussing all these characterizations. So while filing a startup or any party can actually substantiate their mark or can actually stand by their marks with before the examiner more prominently and more effectively. These are the example of the word marks. I have given the most prominent figures which everybody know. So the Disney or Dunkin' Donuts everywhere. So these are the word marks. So when a word is graphically or in a colorful combination have been represented, it actually qualifies the ground to be get registered as a trademark, right? So these are the numerals. I was actually aware from the very much numerals, but I thought this 555 detergent cake is the most prominent one numeral which I have seen across all over in India. So I'm not saying that you have to present your numeral in this manner only. These days the competition has enhanced, but yes, if a numeral 1 is there, if it is somehow distinctively given before on the form TMA, then it does qualify the criteria of getting a numeral to be registered. But please mind it should not be a computer font, because then if you provide to me with a computer font, like if it is 722, right? So I just have given it in an italic manner only. So these computer font are actually nowhere shows that it is an intellectually a brain has been applied in forming a mark, right? At times many startups do have numerals in them, and what they do, they make these numerals in a prominent figure and they say please don't give exclusive right over the rest of the things which are written on my mark, but please give the right over 0777 or something like that. So please keep this thing in mind when you are coming with such kind of things, whether it is word mark or numeral mark, right? Please don't bring it in a computer font, because it is quite clear that computer font is something which has already been with the AI, right? So nowhere your intelligence or your intellect has been incorporated on paper. So on what ground you think that the registrar of trademark does accept your mark and can get it registered as a trademark? So while choosing also, no, one need to think it is not only with respect to numerals. If somebody is coming with what we can say, somebody's coming with the word mark also, they have to keep in mind that computer font should not be there, right? There are normal set standards, Arial, Georgia, Times Zone, New Roman and all that. So these fonts should not be incorporated. We have gone through these several of things we have seen across. Also the slogans and phrase are also can also be get registered as a trademark, but there are few limitations. I have first discussed the limitation that if the small industries actually do this thing, normally what they do, they come with a trademark. You need to understand, slogan has its own registrability, getting registered as a trademark, and then the mark is also a different thing to be get registered as a trademark. So what happens when some enterprise or a person or a party applies on form TMA? What they do, they actually put on form TMA the mark, and at the same time they're actually mentioning their slogan also, right? Now the only you need to understand, only the mark can be get registered, because on a single form 2 marks cannot be given. If any startup or a party wants to get that slogan registered as a trademark, they have to apply on a separate form. So these two things are getting registered on different things, and these two things are required to be applied on different forms, right? And the important thing is, once I have came across through, I won't name the party. What happened? They have applied for us for this startup. It was a startup file only. So what they happened? The word mark was there, and a slogan line was there according to the applicant. What applicant said that this is my slogan line, and slogan line was like best in quality. So best in quality, so it actually was a value statement. You haven't applied your brain. When we go with the advertisement, we hear the jingles, right? So these jingles can be used as slogan. Get my point? One line or two liner. For example, we go for a Nike logo, right? So it's like I'll do it. Or McDonald's does have a statement of I am loving it. So that I am loving it has a criteria of getting registered as a trademark. Why I'm saying I am loving it can be get registered as a trademark, because it is not, one, it is not promotional in nature. Two, it is not motivational in it. It does not have any motivational value. Also, it does not say that this is my best thing, best in quality, best in best, bestest. So there are certain kinds of words, and actually where कोई form of verb नहीं होता है, but still people say that this is the third form of verb and we are applying for it. So you need to understand that even though slogans and phrases are required to be distinctive, but please understand it should not be descriptive in nature. You can't describe. People need to differentiate this thing. It cannot be description. It cannot be a 4-line paragraph. So 4-line paragraph can't be considered as a slogan or a. You can go for it copyright. You can get it registered in literary work, but you can't get it that paragraph registered as a slogan or a tagline in trademark office. So this is the thing. I have given some examples of the slogan. So it is eat fresh. So right now I does not know the actual status, but when I actually studied, so eat fresh was the TM. So when the TM is depicting, so it means the trademark is applied and it is pending. When it is encircled R, it means the trademark is registered. Keep calm and carry on. Most of the people used to keep this as in DP, or at times when they are annoyed, they used to keep it on their WhatsApp status, but they do not know that actually this is a registered slogan. It is a UK government slogan. When they were going across to the war and to promote their or to encourage their soldiers, this was the slogan which has been given to this given to their slow soldiers, that keep calm and carry on. That is the reason I'm saying that we come across daily, we come across through many of the trademarks, but for the lack of the knowledge, people do not know that these are the trademarks. This is the scenario. Coming to the service mark, which is basically the part where startups do consider themselves like they have a role to play. So you want your companies to be get distinguished from the others ones, and you want to get your mark to be registered, and somehow you want to get established. So it is called service mark. But in office, what we do not categorize it. For that purpose, we are having classes. So 1 to 34, if somebody is a manufacturer, they'll go for 1 to 34, they go for the classes. But if somebody who is dealing in the services, the classes are 35 to 45. So any startup who are not dealing in manufacturing, but they are dealing in any kind of service providing agencies like legal consultation or insurance consultancy. So for that purpose, you have to search out your agenda in these classes. So it actually falls in from 35 to 45, and this is also available on the website. It do pop under the drop down of trademark, and there you can find it form and fee. And there are the classification of goods and services. This is the drop down which will be available on the website after once you click on the trademark button, which is available on the website. There the one is supposed to go for it. And if somebody is dealing in manufacturing, for example, industry is dealing in clothing manufacturing, he just started. So the appropriate class is class 25, right? So this is the thing. So we do not specifically use it, but yes, when you go out for the platform, you can state that mine is TM pending and mine is SM. It means your mark is service mark, which is registered. Once your service mark is registered, it will be encircled R against your thing. So these are the examples of the some of the service mark. I have chosen IRCTC. So this is the service mark which provides, everybody know that it deals with our Indian Railways, right? So anything which are giving to the public at large a service, I don't think so that I need to make them understand that what is the service or what are the kind of providing services and all that. But for the better understanding, I just need to make, please look at the IRCTC. So IRCTC, it is a word mark, right? And then it has been elaborated Indian Railway Catering and Tourism Corporation Limited, right? So it is a trade name where the larger companies, they are having a long names, but the long name is not possible to be used. So a smaller form is used, so in the similar manner, right? Then, and on the above, you can see that IRCTC is somehow, the R is there, but then it is a graphically represented. So each of these things can be get registered as a trademark. One thing, the government of India can establish in the rest of on the public at large globally at the platform, instead of using Indian Railway Catering and Tourism Corporation Limited, they'll represent themselves by using IRCTC, right? Like for example, Ashocham itself, they are having the I think it is Associated Chambers of Commerce and Industries of India, right? But when you globally use yourself, I don't think so you introduce yourself by using these long names, right? You use the shorter form. So this is what I'm trying to make them understand. Industries can also incorporate themselves in this manner. They can also utilize the platform in such manner. This is how I'm just giving the devising methodologies in which manner they can actually use it. So these are the character trademarks. Amul Buttergirl was the very much opening video from the Assocham only. So when the character itself has such a distinguished value, a certain audience does know the product just by looking at the character. The Joker character, we know just by looking at the show, we know it is McD, right? So in the similar manner, the industries can come. They can come for these characters. They can distinguishingly represent their character, and you can actually convince the registrar of trademark and the public at large at the same time that you can find me just by looking at this character also. So these are the kinds of the trademark. The letters can also be get registered of trademarks. My opening lines were that only. So these are the few examples of the letters, but all these are graphically represented in a different manner. If anybody will say, I know I have came across this question many times, that DNG is actually a computer font only. For that purpose, the thing is, if already the applicant does have gained a certain amount of audience, if they're having a certain amount of audience and they are showing that I am already established, my goodwill is established, and these are the affidavits of my parties, my clients and all that. So then in that manner, these kind of marks can be accepted, right? You are already having a reputation. It is not at all required that your reputation is supposed to be at national or global level. It is not at all mandated that it has to have a trans-border reputation, right? In your area only, you are having the certain amount of audience. So in that manner, you can get your mark registered, right? So, but that is subject to limitation. Every time it cannot happen. And certification of trademark, these are few of the examples of certification of trademark. When you are going for food, we know if it is FSSAI approved, we used to eat that only if you're taking out from something. So these are the certain standards also. When somebody is a startup, when somebody is a micro industry, they need to understand that they have to go for certain kind of standards also. When you're getting approved from these standards, this will somehow establish you only at the public at large or before the registrar of trademarks also. You need to understand that you are qualifying certain regulations, certain standards. You are somehow complying all the legal impediments and the things. So that actually will support you to establish yourself before the public at large, or in nourishing your business, or to gain the people and things. So this is what I'm trying to make understand. Also, when I given an example of IRCTC, so this is what I was trying to say, that this is collective mark. When an organization uses a name, but their members can also identify by that name, right? So this is the example, for example, Tata and Sons. So this is a collective trademark. It means not only the organization, but its members can also represent themselves by using that trademark. So the collective trademark is actually taken by the organization, but its members can also represent themselves in the before the public by using that trademark. I am working in trademark registry. I am working in Tata and Sons. I am working in Reliance. So this is what I was trying to make understand. This is the value of collective trademarks. So even a startup can establish themselves in a manner, it should establish itself in such a manner that its member can also represent themselves before public at large in the same manner, right? So this is the thing. Trade name, I have just given an example. It is a simpler form which is used by the companies instead of their long and formal names. When I have given you example of Ashochem and IRCTC, CPAM is also one of the example, Creative India, Innovative India, but then it's not, it is basically cell for IPR, promotion and management. So it is a very long name for public at large is not possible. So even industries can take this thing in mind, whosoever the micro industries. When they're having a bigger name, they can come for a shorter name and they can get their name get registered as a trademark. They can come before the public with like that also. So these are the certain criteria. It should be unique. It should be easy to spell, easy to remember. It should not be contrary to the law. It should not be descriptive. It should not be deceptively similar. It should not be copied. When I say deceptively similar, I expressly want to make understand that it should not be copied from somewhere else. This is what people need to understand, that your work is your work and it should not be copied by anybody else. This is what deceptively similar actually needs to understand. Also, it should not be of a nature that it confuses the public at large. We have came across a lot of things like I'll give you a very normal example. It's Nike, and when N is replaced by H, but the rest of the logo is same. So it should not be of that nature. It should not be generic in nature. For example, I'm saying Disprin or something like that. So all these are the generic terms now. So generic words can't be used. For example, my name is quite common, Preeti. So name can be get registered as a trademark. But if I am establishing it in a different manner, then it's okay. But I'm simply giving Preeti in a computer form. It's not possible. That is not the scenario. If somebody comes for a with a name like my trademark is Kanjivaram, no, that is a geographical indication. Yet that Kanjivaram can't be given as a trademark to you. Also, the most important thing, it should not be in such a manner that it is hurting the religious sentiment of a particular sector, right? Like as I know, USA has given the image of Lord Shiva on the bathroom mats. So it was actually objected by Indians by stating that you are giving these foot mats, whatever the color combination, give it, but then the image of Lord Shiva is supposed to be removed from that doormat because it was actually hurting the sentiments of the Indian that the one of our idol is actually under the feet or somebody else is rubbing their feet on the image of the Lord Shiva or on the face of the Lord Shiva, which was actually quoted. So these are the things which when somebody approaches for a trademark, you have to select your trademark wisely. You have to think. Also, it should not be prohibited. These prohibited mark, it should not be well known. Also, it should not be proprietary name, non-proprietary name. Also, all these names are available on the website. I would suggest before searching, please go for that also. So these are the things that when somebody comes, please look into it. Yes, again, it is very normal thing that yes, anybody can say, ma'am, registration is not mandatory. Exactly, registration is not mandatory. But you know what? Then you cannot establish yourself. You cannot get your brand recognition. To get your brand recognition and to get that brand secured, so for on this competition level, you have to get this registration also to make your brand as a valuable asset, to establish your goodwill, or also to get yourself a unique identity, to prevent the unauthorized user from using your mark. You have to get this registration, because if once you get a registration, if somebody is using it before you without your permission, your license, your agreement, then certainly you can prevent that person. You can stop getting damages whatever is happening to you. and it will be given to you for 10 years. So kind of you can say that it stays forever. Once you get it renewed again, it will stay forever with you. It is not just like that 60 years in copyright case, 60 year or lifetime of the author, or 20 years or 25 years when we are having different kind of things, right? So trademark is something you please keep it up with yourself. You get it renewed. You please be vigilant. And trademark can be applied by anybody. These are the categories. And also please when applying from online, please. Should I continue?
Yes, ma'am. Please go ahead.
So when you apply for the trademark now, please, I think Harsh sir is going to make you understand that with search process and all that, right? So even when you are going for the website now, starters are required to think about their category. What happened now, instead of choosing them their a single form or something like that, they don't use their category correctly. Like if I am being the single proprietor, I want, like I am the one, the proprietor name is Preeti and the category is individual. But a startup is applying, then the category cannot be individual, right? So you have to check out your categories, because once you file a wrong form, those clerical errors, those amendments are only executed after paying the government fee. Each and every amendment is subject to a form, and that form is subject with the proper appropriate fee. So instead of, and this will actually delay your process of getting your trademark registration with it, because normal tenure is almost a year, because within a month or 2 months the application is examined, and if there are objections, then the objection will take 2 to 3 months to be get resolved, because there are plenty of applications which are coming with the registries, and your series of application will actually play the main criteria of coming your application before any registrar if your matter has been objected and your replies are not satisfactory. And if your reply has been satisfactory or no objection period is there, then your proposed mark is actually kept in a journal. The way newspaper is published, in the similar manner, these accepted marks are published in a journal, and that journal period is 4 months. So for the 4 month that mark is open, and that is a mandated statutory period. So while applying the form, please try to fill it correctly. Don't go with the errors, because it will automatically delay your procedures only. It will actually somehow delay your mark to be get registered before the registrar of trademark. And once it is accepted, then only a registration of registration of trademark is executed. But if in the journal period it is opposed, somebody has a problem with the accepted mark by the registrar of trademark, then opposition proceedings are catered for in the manner in the court, because we are the quasi judicial authority. So that is having a period of 2 months, 2 months, 2 months. So in the similar manner, we do cover 6 months. In the 2 months kind of, we have categorized totally 6 months in 2 months. So, and then again, hearing before the, for the opposition proceedings, the hearing will take a period in the similar manner. I should not say, but we have dealt with a matter which was actually the application from British India. So you need to understand that please, and to avoid these kind of things, objections and oppositions, the only solution to is this: don't make it copied, make it creative, make it innovative. If it is copied or not innovative, or somehow whatever I have discussed, do's and don'ts while choosing a trademark, the mark will automatically get your effect. And so this is the procedure of registration which I just told. Trademark search, which is left with Harsh. He will actually make you understand that how a trademark is properly searched. Then an application is filed. Application will get examination. That whole process of filing, replying, it will take at least 1 to 3 months. And if reply is not given or given, there are having their individual actions. If it is not given, application will get abandoned. And if the reply is given, if response is accepted, then the application will published in journal, and the registration will be provided for 10 years. So this is the reason I'm saying, already for getting a trademark, the statutory time period is already quite long. So if you're not vigilant while applying, you are actually being technically somehow, or some amendments are required, or no brain are used. So this will affect automatically, this 12-month period will get long. So at times I have seen, and even Mr. Shah also have raised this issue that people have approached them that how much time it is going to take. It is actually dependent on you. If statutory period is there, so I don't think so it will take time if the trademark is properly searched, properly applied, and it is innovative and nowhere copied. So if do's and don'ts are catered for, while filing up the form, all the requisite and prerequisite details are complied with the requisite fee, appropriate things are done, nothing will happen other than the statutory time period. But if there are lacuna on the part of the party applicant, then certainly being on the part of department and being on the, we have to be vigilant. So vigilance is actually required on the part of the applicants who are filing, who want to get it registered as a trademark. This is the opposition proceedings which I'm saying, that once your mark is published and party is having objection just because they are saying that it will affect my business, it is copied, it is somehow phonetically related to my mark. So this is the stage where the period will actually take time. 2 months, 2 months, 1 month. It is almost 5 months, and then 2 months of filing the counter statement, and then it is automatically 8 to 9 months of completion of proceedings of opposition. This is what I'm trying to say. Other than the statutory period, other than 4 months, if opposition do comes, then it is automatically 8 to 9 months to even get the proceedings completed. And once these proceedings will completed, when the matter is mature for hearing, then the registrar will hear, and then it depends that what are the evidences, how much the discussion has been taken up, right? So industries, our applicant, or whosoever are listening, please try. And the only resolution to this problem is, please make it innovative, please make it creative, please don't copy it from somewhere else. That's it. I think I should wind it up. I think I have exceeded my time limit. This is the rectification proceeding. It is actually after registration. The important thing too in it, opposition is something which is available to the anybody, but rectification proceeding is only against the registered mark. One thing. Second thing, the third party who has actually aggrieved and his business has affected from the registered trademark can only file a rectification. And even you guys also can, if you're a registered trademark holder and a mark is already registered with the registrar of trademark, and you being the registered trademark holder, your right is negatively affected by the secondary registered mark, you guys can approach for a rectification proceedings. Because many times what I have seen, people do not know the rectification proceeding, they directly go to the police or legal opinion under section 115. So you need to understand, even if here registry is sitting, even if your mark is getting hampered, somehow your registered mark is getting affected by some of other mark, you guys can file a rectification proceeding on form TMO, right? So you guys can do things also. Please be vigilant with the journal. Journal is not with regard to your published mark. Journal is also with regard to the fact that any other mark which is accepted by the registrar of trademark and it is affecting your business. So in that manner, also you can file an opposition proceeding against that registered trademark. It is bipartite. It is not only with regard to your filing. It is also which has been, because human error is there, might be in eyes of registrar of trademark, this mark does have this capability of registering the trademark, but then your business is getting affected. You come with a proceeding of trademark opposition, you file opposition or you file a rectification proceeding, proceed with it, deal with it, fight for it, but then please be honest with all these practices, because it will actually affect your business if you are somehow not completely informed, not applying it appropriately, or any other mean or practice is applied somewhere else, right? So I think I tried to make understand these things. I was actually having a really short span of time to discuss these things with you. I'm so sorry for any kind of mistake if it has happened, and all
Ma'am,
questions
please
are.
answer the patent questions.
Which question?
Patent protection questions.
Okay, sorry. So I need to make one thing understand. My specialization is only in trademarks. So I do not have patent thing, but I just, okay, there are several questions. I need to go through it. If anybody can repeat the question, I can find it, because there are many questions or things I've written. I'm not able to find it patent question.
Preeti, mine, can we bring Harsh over, and he can show the questions. And if you are not available, maybe if you can send us your email address, and what we could do is through AskChem we can funnel those questions over to you.
Sure, sure. So I think one of your coordinate, Kirti, she is having my email address, right? So
Yes.
it can be sorted there, right?
Yes.
Yes, ma'am.
Yeah. No, this was very wonderful presentation, very practical information that we all learned today. And from the chat
Thank
box,
you so much.
I'm not sure if you had a chance to even see that. Everyone was just chiming in that this is very nice. They were engaging with it. So, really wonderful information. Thank you so much.
Thank you so much. Thank you so much. Thank you.
Yeah, thank you. So, let me bring over. Participants, please stay around because Harsh is going to show you something which is even more practical. Like in the flowchart that Preeti ma'am was showing, he will cover a very critical part of that. So, Harsh, without further delay, over to you.
Sure, Hemang. I'll just skip the presentation and directly go to the search, just in the interest of the time. So you can see my screen, right?
Yes, I can.
Okay, all right.
So, you
So
can, what the URL is, and then go further.
sure. I'll share the URL in the chat as well later on.
Perfect.
So this is the IP India website where you can go, and here is the link to the trademarks. So if you click on trademarks, it will take you to the home page of trademarks, and there is a link here to do a public search. So once you click on this link, this is the page that opens up, right? So you have three different options to do a search. One is the word mark, one is the Vienna code, and one is the phonetic. So one of the most important things while doing a trademark search is based on the type or nature of your goods or services, you need to identify the classes. So this is the most important step before you actually start with a trademark search. So this can be done in what is known as class details. So there is a link here. When you click on this links, this is the page that opens up, right? So let's say you are searching some, you want to, your business or product is in the category of vehicles, right? So you just do a search to identify the classes. So when you type vehicle, you'll get a bunch of results, right? So you can see that there are the number of results are like close to 2000. So you can sort this. So once you've sorted, you need to identify the class. So that can be done by scrolling to the page here. Just look, these are nothing but these are all classes or classifications that Preeti ma'am explained. So 1 to 34 are related to goods, and 35 to 45 are related to services. So so I know that the vehicle category is in class 12. So we'll directly jump, we'll choose class 12 and do a search. So first is you're selecting a word mark and then performing a search. Let's say you want to search for a known mark like Bajaj. You want to know what all trademarks that Bajaj has. You just type Bajaj and put search. So once you click, so you see you can there are some 451 marks that are being shown up. So you can browse through these, and then if you want to generate a report, you can select the marks that you're interested in and also generate a report. So if you click on report, a report would be generated that you can save. So this is just for your reference. So it will briefly summarize the application number, the class, the conflicting mark, and who is the proprietor, the address, current status, whether it's there or whether it's abandoned or removed or whether it's granted. So these details will be there, and it will give you the description of subclasses. So in goods and services, you can look here. So motor vehicles, tractors. So these are the subclass definitions of class 12 in which this particular mark would be protected. So you can print the report and save it, or you can just go back to the original search by clicking on this link, or you can go to a new search by clicking on a new search. So what you searched was a word mark. Now there is something called as phonetic. Phonetic means something which is rhyming, right? So we can do a same search for Bajaj, and it will. So when you did a word mark related search, it showed you only results related to that specific word, which was Bajaj. When you do a phonetic, so anything that rhymes or sounds like Bajaj closely, all those results can be pulled up. So you do Bajaj and class 12, and when you do a search, so you can see here Bhagyas has been cited, and then Bog Cock, which appears to be phonetically similar to Bajaj, has been cited. So it will give you a list of uh, identically phonetically sounding results. Bajaj also is there. If you want to restrict exclusively to Bajaj, then you can do a word mark search. But if you want to do a phonetic or related search, you could choose the phonetic option and do the search. The third option is the Vienna code. The Vienna code is slightly complex. You need to understand the Vienna code classification for that. So there is a link here. If you click on the Vienna code classification, it will take you to this link. Again, you can do a search here. Look for a specific word. Let's continue using vehicle. And when you do a search, it will show you a bunch of results. So all these are related to vehicles. So let's click on one. So it says traveling shows, fairs, fairgrounds, groups with vehicles. This may not be related. And when I choose, let's say this vehicle headlights. So I want to look at which are the trademarks that are filed in vehicle headlights. Now, for you to understand in which class this is, because you won't find vehicle headlights in class 12. So you can go back here, class details, click on class details and do a search. Let's say you do vehicle headlights. And do a search. So it is showing in class 11. Vehicle headlights are in class 11. So what you can do is you can select this code. So Vienna code is generally a 6-digit code. So you can see here it is 13116. So there are only 5 digits. So what you need to do is you need to insert a 0. So it would be 130116. You select Vienna code. And then in class 11, because you identified in, this is the class that you identified which belongs to the vehicle headlights. And when you do a search, so it will show you all the list of all the trademarks that are listed under that Vienna code. Everything that is registered under that specific Vienna code would be available here. Same way you can select the results. You want to select all and then generate a report and save and go through the report later on. So these are all the brands that are there in the vehicle headlight category. So regarding, I'll go back to the search. So well-known marks are here. Again, you can click on this and access the well-known marks. So all these, you cannot trademark them. So this is maintained by the trademark registry. So you can see that these are all very famous brands. Like for example, Amul is here, Google is here, Nestle. So you cannot deceptively modify this or conveniently modify this and try to get a trademark on that. So there's also a list of prohibited marks. So all these anything that is related to probably name of God and all. These things are again prohibited. The list is there on the website. Likewise, the INN names which are related to pharma substances, pharmaceutical substances or composition of that, again, these cannot be trademarked. So this list also is there on the website. So that is just a brief of how a search can be done. So I can share these links with you in the chat. So if you have any questions for me or PT ma'am, would be happy to take them.
Thank you, Harsh. I think there are a couple of questions. One is from the same person, Anita Chopra. Can we register an abandoned mark? And it probably somewhat related. If something is registered already in a different class, like say class 10, can you register the same word in class 5?
Priti ma'am, would you like to take that question, please? Is she around?
Sure. I think her video was just on, but she's on.
Sir, just a second. She is joining.
Yeah. Okay.
I'm so sorry. I am actually involved with WIPO meeting, so it is getting conducted now. India is participating in Indian Broadcasting Treaty, which is proposed by Geneva, which is proposed at SCCR Geneva. So that is also. I just note that what is India's stand. So sorry.
No, thank you. Can you stay on for some Q&A?
Sure. I just made an arrangement for that.
Thank you.
Please.
So I think I'll repeat the question. And the question is, can we register an abandoned trademark? And also related to it is, if a word is registered in, let's say, class 10, could you go for the same word for registration in a different class, like class 5?
Sure. So one thing is, once your mark is abandoned, so I need to make understand that there are 2-3 grounds where the mark is abandoned and refused. So abandonment and refused. So the question is about the abandoned, not refused. So if anybody does have a valid ground against that abandonment, then on the form of TMM review, that application can be revived, right? But it should be, there are the grounds whether the counter statement was not filed or whether the reply to examination report not filed. There are the grounds on which the application gets abandoned, right? So these are the 2-3 grounds on which an application is get abandoned or an opposition is abandoned, right? So if these scenarios happen, then on the form of TMM review, by it is, I guess, 1,000 rupees if somebody files it online, and it is offline. And if it is online, then it is 900 rupees, right? So if that form is filed, so against that abandonment, for that review can be catered for, but then it has to be validated, properly validated in principle of natural justice. That can be catered for. Second thing, it can't happen that if your mark is abandoned today and you are filing review and you want it to be get revived after 2 years. There is limitation period of 30 days. So within that limitation period only, you can file for the revival of that abandoned mark. If anybody wants to get that abandoned mark to be get revived even beyond the specified limitation period, then you have to justify. First, you have to justify that why your review should be taken on record, because the limitation period has been crossed up. And if that condition has been taken up, only then your review with regard to the abandoned mark can be taken up. So yes, abandoned mark can be revived. I have given you the limitation period. Second thing, word mark can be get registered under class 5 also, which is for pharmaceuticals. I have seen GBL 22. Today only I examined an application GBL 22 for class 5.
Okay, thank you. Let me go for questions in the order that they were sent and I'll request either speaker to chime in.
Sure.
So question is, how are sound and smell marks examined and compared against existing marks, and how is the degree of similarity ascertained?
So when somebody applies for a sound mark, the notes are given. So it is just not the music, the notes, the musical notes behind the formation of that particular sound mark is actually applied. And we are having the way when Harsh sir has shown you that this is how a search is done, and then a pop-up result pop out, the list of the already registered, pending or removed marks popped out. In the similar manner, we are having internally inbuilt system we are having for the sound marks which are registered, and then those notes are compared to that one. In that process, AI is and IT team is involved. No, directly examiner is not involved because we do not understand notes, right? Because a composer of that particular sound must have been understanding with regards to the notes of that particular sound, but we being from the legal fraternity can't understand that. For us it is like kala akshar bhains barabar. So in that manner, AI and IT somehow involved in comparison. For in respect of smell trademark, I have already told that no such what we can say, we haven't received a form, so till I do not know whether that device or mechanism is not that is there actually or not. But then for a new upcoming project on behalf of trademark registry, we are trying to modulate our existing module. In that, we are trying to incorporate a kind of mechanism where the smell mark must have been some kind of, or we are taking it from actually USA. We are asking, we are fetching out that how these marks, smell marks are getting examined on their part, because it is examined in USA and they have registered smell marks as in trademark. So we will try to devise that mechanism in India. We haven't received a single application, and we do not right now. We do not have an explicit mechanism where a smell mark can be examined. But certainly, we'll get an application. So I think that can be fastened up.
Sure. Harsh, would you like to add anything to it, or I can give a different question as well?
No, I think she has covered most part of it. I don't have anything to add.
So now let's change it up to an interesting arena that, it's an age of metaverse, NFT, these, I guess, new digital creations or digital universes that we, I guess, we soon will be living in. So uh, what, what do you think in terms of the current protected trademarks? Would they have the same level of protection in metaverse? And what could be the legal remedies if there is any infringement there?
See, for infringement, though, we know that if a mark is registered, then infringement proceeding is there. You can sue for that thing, and we can say that rating can be done for that purpose of matter, and compensatory value also, and then what we can say, sentence is also there. If somebody is actually said for with regard to somebody find it that he is the particular XYZ is an infringer. So legal remedies are always there. But if you are unregistered, so we have no other than common law remedy. You do not have anything, right? So that is the reason which I wanted. Coming to the metaverse, so yes, certainly it can be what we can say can get protected. Can you repeat with regard to metaverse, because I actually got the second part only, not the first one.
Okay, so the first part is that how are the the current trademarks and all that, how would they be considered in this age of metaverse and NFTs? Like, would they still be applying there? I'm guessing that the question is that, let's say if there's a trademark which has been granted, that trademark is valid in India, right? Meaning there's a physical geography in which we can say the trademark is valid for. But metaverse is this, virtual world. So what's applicable?
So obviously for virtual world also, because I'll tell you what, somehow then copyright also get involved in that thing, because then these days we are also fighting over that whether for these metaverse or broadcasting thing, whether internet or OTT will be included or not. That is still it is a subject matter we haven't included it, because the 2016 when the ministry itself issued an office memorandum by stating that in broadcasting we do include internet also. So digital world is also somehow required to be protected. And this is my personal opinion, because right now India hasn't given a particular or exact legal position stand over that thing. So it can be protected. And yes, digital world, obviously, when it comes to digital world, other than the content, the name through which your digital world you want the people to know about it, certainly that is a subject matter of trademark and it can be get protected. And if it is somehow get infringed, then again infringement proceedings can be initiated against it. So there is the thing, but the content in that digital world, when I'm asking, that is a subject matter of copyright. And for that purpose, yes, again it can be get copyrighted and it can be protected. But then exclusively internet and OTT, if I say, that hasn't been right now included. And even in Chennai High Court also, it has been the ministry which has actually passed an OM, it has been questioned that why did ministry included internet and OTT. So even that matter is a sub judice. So when with regard to sub judice matter, I can't comment more.
Harsh, anything you'd like to add over there?
No, nothing really. Yeah, it's still debatable. We don't have clear laws. So it's a evolving thing, just like in patents, right? When it comes to AI related patents, it's a debatable topic. Likewise, in copyright and trademark also, it's quite debatable. And we are yet to see some solid case laws and outcomes before we can, come to some kind of conclusion.
Yeah, I agree. The other day, so again, this is one area where I'm trying to keep up with the trend as well. And I heard about someone who's a creator only in this virtual world. So this person apparently creates songs which are only available in this metaverse. So meaning, let's say there's some aspect of copyright which is there. Now, what happens in case of any issues that someone is infringing that in the real world? Now, what are the remedies that this virtual creator has in the real physical world? And makes up for an interesting discussion, but I don't think we have a clear-cut answer yet.
Reason behind, I want to add, I'll tell you what, because the platform on which is it broadcasted, even they consider themselves as an author. They says that if our platform would not have been available, the whosoever is the author or the creator of the content can't get the authorship. So broadcasting on the platform, the organizations which are providing these platforms to the public at large, they want themselves to be considered as an author, but then the original content creator want the royalty. And here in this scenario, royalty can't be decided. So this is the main issue and main fight, and which is actually debatable, because right now our law is not that much stronger, haven't came to that position where we can actually particularly state that this is the person who shall be considered as an creator or as an author, and this will be the one person who shall be eligible for the royalty and all that. Because many of the things do get involved. There is transcription on, and then at times there is interception. Somebody else is intercepting in my signal without any appropriate license and agreement, and then that person is rebroadcasting it, or somewhere the transmission of signals, a broadcasting organization which is supposed to transmit the signals at A, B, and C country, and in between, before going to the C, country D is intercepting it, and again they are retransmitting it. Stored program, like time zone is something like that. Like right now it is 4:30, but at Geneva it is like, but it is noon at there. So the program has to be stored at somewhere, and then it has to be broadcasted. So this is the actual fight between the authorship and the actual who is considered required to be understood as an owner, and where this royalty should be given and all that. I'll give an example. If somebody is given a live performance, if you're a live performer and you say that this is my right, and then the organizer said, no, I have given you the platform, and again Copyright Act is silent about the live performance, we haven't protected it. So these are the scenarios. So metaverse is that is the reason I was saying that it actually gets you into quite detail. It is a very different subject matter.
And then thank you for explaining that. I think we'll take one last question.
Sure.
And this,
Sir, I have a question, please.
sure, please go ahead.
Uh, when we have to do a prior research before registering for a trademark, whether it's a word mark or it's a device mark, we understand we can do it through the public search and other softwares which are available, and also the Google and other things. But when it comes to device mark, when an applicant wants to apply for a device mark, somehow it becomes difficult because word mark is easier to find, but we don't know how can we find a similar word mark or a similar color logo is already registered or is about to be registered or has been applied? So Vienna code is one of the options, I get it. But how do we really process or how do we really utilize Vienna code and other softwares to find the already applied or registered device mark in particular?
Ma'am, you can answer that.
You want me to answer? Arani, sir, I think you are the one. So if you want to know that, then appropriate may when Harsh sir has shown you that word mark search, he has shown you the drop downs, right? That the word
Yes,
mark
yes,
search or start with or that drop downs were there, right? So when
yes.
it comes to the color combination, it is when it is exclusive the color, I would suggest you to describe it while searching it. For example, if it is only a image of an elephant, right? To just say it, device of elephant or elephant device. In this manner,
Okay,
the exact appropriate result will pop out other than Vienna codification, right? So because at
okay,
times the Vienna codification, Harsh sir must have said it like it is quite technical, so it is not very feasible for everybody to search it Vienna codification, right? And at times we being the examiner, when we get only a color combination, so for us also it gets difficult to get it codified through Vienna. So there are these
right,
things. So in a layman context, now what this is the trick we use. We describe it. You can just say gray color gray combination. You just write the color. So in that manner, if anything which has been in TMA, I'll tell you what is this thing now. Why do you go for trademark, word mark search, or start with or contain or something like that? When you apply for a mark in form TMA, there is this column trademark, and there you mention your trademark, right? For
right.
example, if it is a device mark, for example, it is an elephant, and in that form 8, trademark column is mandated to fill up, right? So there you will fill device of elephant. Example, got it? So that device of elephant which you have written, na, in that similar manner, it will get codified in trademark module. So that same thing is available at the website. So once if somebody is supposed to actually trace out the devices or the color combination only, it is the data which has been given to us by the public only, or which we have ourselves codified. So this is a mixed data. So this is the reason why I'm saying that when you are actually searching, search it in a manner device of elephant or elephant device or a gray color combination or gray color. Just write it gray color. So at times it does give you result. And it might happen that in that class that color is not available. So that is the best thing for you. That is the thing. So you guys can do that thing.
All right, ma'am. And ma'am, one more question. Thank you for the first one. Ma'am, a second question is regarding rectification of trademark only. For
Hmm.
example, one of the applicant is getting is aggrieved party because the similar trademark has been registered in a different class. However, in a wider scope, that description of class is also, for example, if my client is dealing in agricultural products
Hmm.
and that is under class 30, and the opposite party gets his similar trademark, ditto trademark registered in class 29. However, they are in a specific field, that is coconut oil or something. So I
Right.
can always suggest my applicant to file for rectification, but I just want to know what are the mandatory documents which we can provide to convince the registry or the court, which are substantial for our case, and apart from the regular invoices and other things.
So through your question, I realized that you are into filing of trademarks and dealing with trademark applications, right?
Right, ma'am.
So you must be aware of the fact that the thing which is your question is actually one of the ground to get a mark to be accepted in different class, right?
Yes,
Even you
ma'am.
must have done the
Right,
same thing,
right, right, right.
right? So 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 this is the thing. So what you do in that scenario, see, rectification proceeding is class irrespective, right? It is nowhere mandate like if a mark is registered in 25 and yours is like in class 5, for example. So a class 5 registered proprietor can file a rectification proceeding against class 25 registered proprietor, right? So this is the thing. It is mandate actually to somehow justify that how that XYZ mark is actually affecting your mark. But if you have gone through Beretna, you must have realized that there is this specific word which is nowhere in other provision. It is stated aggrieved party. You have to first establish that the person who is filing rectification is actually aggrieved, is actually negatively affected. Only then rectification is admissible, right? So as a matter of fact, it is this is somehow which is at very first stage it is seen in court. So in practical proceedings here it is not seen.
परसों में बताएंगे तो क्या काम है, क्या करना है, क्या नहीं करना।
10-15 मिनट का काम होगा।
Sorry for the interruption, ma'am. I think you went on mute. Ma'am, can you unmute yourself? Preeti ma'am, you're on mute.
Sorry. I'm so sorry. So where did I lost you guys? I don't remember where did I lost you guys. I started from the place where I said the party should be aggrieved one and they have to establish this ground that yours is the one who is aggrieved with the registration of this so and so mark. So make one thing clear that prepare with the invoices and show that how your mark is negatively affected in that sense. Right, this is the prime condition you have to actually establish before filing rectification. Make your evidences strong. If your evidences are weak, then this is 100% sure rectification will get dismissed. Rectification will get definitely dismissed, because else I'll tell you what, this will be against the principle of natural justice, because every time then any random third party can use this rectification proceeding as an hanging sword over a registered proprietor.
Correct, yes.
Right. So you have to actually establish it with your actually that with your evidences. Your evidences should be must secure and important things and the prominent and invalid evidences. That is the important part. Unless and until it is not established, actually the arrow can turn towards you. This thing can happen. This is for sure.
Thank you so much. Thank you, sir.
Thank you, ma'am.
एक बार कॉल करो मैम, केबिन में है, देखो चेक करो जाके ये वाला केबिन।
So I think we are at the end of our webinar schedule for today, and I our very passionate ma'am Harsh gave a lot of value.
You are not audible to me. Sorry.
Sorry, I'm being put on mute because of the interruption.
Okay.
Apologies. So, thank you so much to both of our very passionate speakers, Preeti ma'am and Harsh. I think every attendee was very well tuned in. The chat box was really active, and you could see from the way they were asking questions also, even on the phone, like by unmuting themselves, or over here they were engaged. So due thanks to both of you, and very practical information was shared. And this is of utmost relevance to startups and SMEs, right? As they are building their companies in a nascent stage. If they take care of these things now, they'll be set, for the many years to come. But the flip side of it is, if you make any mistake right now, IP tends to be a field just because of the processes and all that. You can't just wait for, okay, I'll do this filing 5 years later. It doesn't work that way. You may miss the boat. So be proactive. Take everything that Preeti ma'am and Harsh have shared with you. Take that to heart. Do practice it. And with ASSOCHAM, they have an IP facilitation center. You can reach out through that. Harsh has shared both his coordinates as well as the coordinates of the IP in their office in the chat box. If there's anything, please let us know. And finally, I'll also paste the links for L2 Pro. Please download it. I know a number of you have done that. It's a wonderful reference material. And thank you so much to all the attendees also for your patient listening today. Thank you all.
Sir, that patent question, वो patent वाला question, sir.
Abhijit ji, आप पूछ लीजिए, I can answer.
जी सर, वो पेटेंट वाला क्वेश्चन था कि पेटेंट तो सर बहुत महंगा पड़ता है, 2-3 लाख रुपए। कोई ऐसा है, जो मैंने कल गूगल फॉर्म्स में क्वेश्चन आपके फिल किया था, कि कोई
हाँ,
ऐसा वे है जिसमें हम पेटेंट भी ना कराना पड़े, और कोई ट्रेडमार्क या कुछ भी, मतलब कुछ ऐसा हो जाए जो हम इन फ्यूचर शो कर सके, अगर हमारे उसी टाइप का कोई स्टार्टअप या आता है मार्केट में, तो कोई एफिडेविट ऐसा हो, कुछ कुछ भी ऐसा लाइबल डॉक्यूमेंट हो।
ठीक है. So Abhijit ji, I'll firstly clear your understanding that patent filing is not always that expensive. No, it depends. आप कौन से professional के पास जाते हो. But one thing I'd like to highlight is आप IP India की वेबसाइट पे जाएंगे, you will find patent facilitators. ये IP इंडिया के साथ registered patent facilitators है, पूरे कंट्री से है. So ऐसा नहीं है कि एक ही शहर से है. आपको देश भर से अगेन पूरी लिस्ट है वहाँ पे. वो लोग आपका काम करेंगे फॉर रियली नो चार्ज. वो गवर्नमेंट को बिल करेंगे. अगर आपको उनके अलावा किसी और को जाना है तो वन रिसोर्स मैंने आपसे शेयर किया, आईपी फैसिलिटेशन सेंटर. एसोचैम का एक है, नेस्कॉम का एक है, तो आप उनको अप्रोच कर सकते हैं. एनआरडीसी है, नेशनल रिसर्च एंड डेवलपमेंट सेंटर. ये सब नॉमिनल कॉस्ट पे काम करते हैं. अगेन आपके फाइलिंग के लिए, अगर आप स्टार्टअप एसएमईज है तो आपको आपके साथ वो लोग डिस्काउंटेड रेट्स करते हैं. और इन सब को छोड़ के आप डायरेक्टली फर्म्स के पास भी जाएंगे. एंड आई रिक्वेस्ट प्रॉब्ली हर्ष टू मे बी चाइम इन कि वो लॉट ऑफ फर्म्स आई नो आर मेकिंग स्पेशल अरेंजमेंट्स फॉर स्टार्टअप्स, बिकॉज वो आपका पोटेंशियल देखता है. और दूसरी बात, जो आईपी राइट है, वो आईपी राइट इज अ नेशनल गिवन राइट. इट्स अ स्ट्रेटेजिक थिंग. तो इट्स वेरी पावरफुल. उसका फायदा लीजिए. हर्ष, ओवर टू
Yeah. Yeah. Yeah, thanks, Hemant. There are MSME schemes also in which there is reimbursement. So up to 1 lakh rupees after the patent gets granted, there you can get a reimbursement of up to 1 lakh rupees that you spend towards the attorney and the patent office fees. And likewise, in MSME, there is also a scheme where they support with reimbursements for patent filing outside India. So if you file outside India, and incur expenses, so up to 5 lakh rupees per patent that gets granted can get reimbursed. Likewise, there are different schemes in MIT, DST, under computer related inventions, electronics, and all that. So there are many schemes. One has to just go and explore and use them.
तो जस्ट L2 Pro का want to chime just one quick comment. L2 Pro का जो रिसोर्स सेक्शन है एट द एंड ऑफ पेटेंट्स, उसमें आपको ये सब पूरी एक लिस्ट मिल जाएगी, कहाँ कहाँ पे आप जा सकते हैं. So Abhijit ji and others, please do not ignore these powerful IP rights. They are
बिल्कुल सर, बिल्कुल हिमांशु जी, थैंक यू वेरी मच हिमांशु जी, हर्ष जी.
Yeah. Okay.
Thank you. And our next webinar similarly will be on like a workshop on the patenting front. So we'll and as well as other topics of IP rights. So we want this level of interaction with all of you. So please stay tuned. And thank you, everyone.
Yeah. Thank you.
Thank you.
थैंक यू सर.
Thank you.